everybody. It is 10 o'clock Central. My name is Jordan Walker. I am an attorney with Seaver Walker Paget Law Firm. Today, we're going to be talking about eminent domain in the state of Missouri, what to do when the DOT wants your property for a road project. And it is 10 o'clock, so we are going to go ahead and jump in. If you have questions during this presentation, we do have a chat function. We also have a Q&A function. I might not address your questions immediately, and there's a decent chance my presentation will answer some of those questions. But in any event, if you have them, we will definitely answer them at some point. So with that said, we are going to go ahead and get started. So before we get into the meat and potatoes of the discussion today, I did want to talk about who we are, what we're doing, why am I mailing things to you. My name, again, is Jordan Walker. I am with the law firm Seaver Walker Paget. We are an eminent domain only law firm. We are a landowner only eminent domain law firm. And what that means is that what the situation you are faced with potentially here in the next year or so, an eminent domain acquisition, that's what we do. We help landowners that are faced with a eminent domain acquisition, usually for a road project. We obviously do other types of acquisition as well. But I do, again, want to preface that we are eminent domain attorneys working on behalf of landowners. We, again, only do landowner work, and that's the only type of work we've ever done. So a lot of attorneys that do eminent domain work usually do both sides. They'll do the DOT side and they'll do the landowner side. We have only done landowner work now and into the future. So as a consequence, because we are landowner only, because this is the only type of law we do, we have learned quite a bit. We have counseled landowners on pretty much every type of acquisition you could imagine. We are a national law firm. We will operate wherever we can operate to help landowners out faced with eminent domain acquisitions, and that, of course, includes the state of Missouri. So while we are a national law firm, we are not a gigantic, huge, monolithic firm. So if you were to work with us specifically in Missouri, you would be working with me. Again, we are eminent domain only. We do this across the country. We have done work in Missouri. We have done work in Illinois. We have done work in Indiana, Ohio, Georgia. You name it. We have done quite a bit of this work. And again, we've learned quite a bit. And the goal today is to share with you what we've learned. And so for your upcoming acquisition, things to look for, what to do when you get an offer, what to do when the state wants your land. We're going to be talking about that today. Before we get into that, though, I want to talk about what actually eminent domain is, because a lot of folks don't know what it is, which, no shame. It's kind of a random area of law. Not a lot of people experience it or ever deal with it in their entire lives. So when they're faced with it, it's not uncommon for a landowner to not know what to do. But in any event, we'll start at the basics. Eminent domain is the power of the government to seize private land and put it to a public use. Now, I will say it's not always the government that's taking land under eminent domain, but for purposes of this presentation, we're going to assume that is government, because we're only working with DOT acquisitions. So in other words, the DOT, the local municipality, the city, the county, whoever's acquiring the land, they have either an inherent or a delegated power to acquire land for a public use. Now, the most common public use we see, especially with governments, is for road projects. Road projects are de facto public uses. Everybody can use them, so they're generally used by the public. They are a public use. So when we talk about the ability to take land, the government, the DOT, they can't just take land and do whatever they want with it. They have to take it and put it to a specific use. And in this case, we're talking about road projects. Not a lot of people are aware that that the state can just acquire land if they want to for a public use, and they can effectively seize it, meaning you can't just reject the acquisition to the point where they go away. Ultimately, they have to build roads. The state, local counties, local cities, they have to build roads. So they have this ability to take that land, ultimately, whether you like it or not. This is just kind of the reality of the world we live in the state of Missouri and in this country. This is a fairly common type of exercise. We see it quite a bit, although, again, if you're not affected, you don't really know about it that often. So they have the ability to take it, but they do, but with that power comes a responsibility, and they have to, that responsibility is they have to pay for it. And it isn't just that they have to pay for it, they have to pay you, the landowner, just compensation for that, for the land and for the ability to take the property. And what that means ultimately is it's not up to the DOT to determine what you're entitled to for your property. They will certainly have a position on what they think your property is worth, but they are not the end all be all in eminent domain. Ultimately, if it gets to that point, you have the right to a jury trial, and you can present your evidence on just compensation to that jury trial. So what that means, again, is that just because the DOT says your land is worth a certain amount of money, that doesn't mean they're right, and that doesn't mean that they just get to take the land for that amount of money. You have rights, and we'll talk about what that is, but just bear in mind that even though they can take it, they do have to pay just compensation. So in the exercise of this power for road projects, there are some pre-eminent domain requirements that need to be met before the DOT or a condemner can ultimately take land through eminent domain. So it's not just that they show up one day with a lawsuit. There is a pre-suit process that needs to be followed. And the first requirement of this pre-suit process is a pre-filing notice. And a pre-filing notice is issued to landowners who are affected by the road project. And this is the first, what I tell people, this is the first time you're going to actually going to hear from the DOT. So when they issue this pre-filing notice. And this pre-filing notice will inform you of the acquisition. Basically, the purpose of the pre-filing notice is to make you aware that an acquisition is pending, or that the DOT wants your land for a road project. The pre-filing notice notifies landowners of their rights. It identifies the acquisition. It is it's a procedural requirement, largely boilerplate document besides the identification of the acquisition. But the pre-filing notice is when you're going to finally know what they're taking from your property, or what they want to take from your property. That's the number one question I get is, how do I know what they're taking? When are they going to issue the offer? When is this going to happen? And I don't work for the DOT. I don't work for the state and the county, and they're certainly not going to be forthright with that type of information to me. So we try to accumulate the information we can, but we're obviously limited. Ultimately, what I tell people is, this pre-filing notice is when you're going to really find out. You can try to contact the DOT, try to reach out, see if they'll tell you ahead of time what's going on. I wouldn't hold your breath on getting a lot of response from that, but you can certainly attempt to try to figure out earlier than this notice if you'd like. But ultimately, this is going to determine another way to determine what they're taking ahead of this pre-filing notice is if they do some surveying and they put stakes in your property. Those stakes they should generally outline the acquisition. Not everybody gets stakes. Not everybody gets the surveying treatment. Sometimes they survey and the stakes obviously fall out or here or there or whatnot. So that's another thing to look for if you're really eager to figure out what they're doing. If they have put some stakes out, that'll be an indicator of what they're ultimately going to take. But either way, at the pre-filing notice, again, it is issued at least 60 days before a petition can be filed. Not necessarily will be filed, but can be filed. Meaning they have to, if they want to utilize eminent domain, they have to issue this pre-filing notice at least 60 days before filing suit. And then the next step in the pre-suit process is the good faith offer. And this must be issued at least 30 days prior to condemnation. Again, it isn't necessarily going to be on day 30, but it needs to be at least 30 days before they can take you to eminent domain and file their eminent domain lawsuit. And that's what I mean when I say condemnation petition. And we'll talk about exactly what that means. But the long and short of it is that's the lawsuit that the DOT files to get your property through eminent domain. When people say I hear a lot that they're going to take me to eminent domain. We're going to go to eminent domain. These all mean the same thing, and that is the litigation stage of the process, where the state actually, or the DOT actually, acquires the land through the courts. So we'll get into that here in a bit, but I just want to be clear on what that means, condemnation petition. So you have the pre-filing notice at 60 days, and then 30 days later, you have the good faith offer. The DOT, the state, whoever's acquiring, must hold that offer open for 30 days, and it must be sent via certified and registered mail. I should state that this offer, this good faith offer, is where our firm generally gets involved, because that allows us to not only analyze your acquisition, but also analyze the compensation package that they presented to you to ensure that it's a proper amount of compensation. So that's when our firm generally gets involved if you are looking for counsel. I will say we definitely get involved with pre-litigation work, pre-eminent domain work. If you just want to, or curious about what's going on, and you don't have an offer, or you want to, or just curious about eminent domain further, or what's going to happen, or you're especially concerned about your property, we definitely, offer advice to the best we can prior to condemnation, prior to this good faith offer. But generally, we don't get involved in a contractual relationship until the good faith offer is issued. So they will issue the good faith offer. It'll be open for 30 days. It will have an appraisal or an appraisal summary. So that appraisal will be done by the DOT or the city, the state, whoever's acquiring. And that appraisal, again, appraisals, not every appraisal is great. Some appraisals are bad. We'll get into exactly what that means, but just bear in mind, just because they did an appraisal and just because they got an appraiser to do it, doesn't mean that that's the end all be all to what you're entitled to. And we'll get into exactly how that can be the case here in a bit. But you have that offer. So let's say you have that offer. It's been open for 30 days. It's a terrible offer. You're not going to accept it. They're not compensating you whatsoever for the damage to your property and what they're doing. What happens then? Well, they need to get the land, and they can't just sit around and wait for you to accept their offer. So what happens next is that they'll file their lawsuit in the circuit court of the county where the property is located. So it doesn't matter where the property is located, the lawsuit will be filed in that county circuit court. And then once that, and you will be served with the petition, you'll be served the paperwork. So it doesn't happen without you knowing. You have an opportunity to participate, of course, but that is the beginning of the eminent domain process in earnest. So you're in litigation. What happens next? So the lawsuit's been filed, the petition's been filed, you've been served it. The first event in eminent domain matter in Missouri is the initial hearing. And the initial hearing is set by the court after the petition is filed. Really, the main purpose of this initial hearing is the opportunity for the landowner to challenge the government's inability or failure to follow a pre-condemnation procedure. I talked about the pre-filing notice, the good faith offer, the appraisal. So let's say the DOT doesn't supply the appraisal or the appraisal summary in this pre-condemnation actions. At the initial hearing, you have the opportunity to show up with counsel, of course, if you'd like, and to say, basically, they didn't follow the law. They should have supplied the appraisal summary. They didn't, and the petition must be dismissed. So that is an opportunity to raise those specific objections if they exist. Now, I want to bear in mind that even if you're successful, for example, on arguing that the DOT did not follow their pre-condemnation procedure and you get the case dismissed, that's great. But what will ultimately happen after that is the DOT will go out again, fix their mistake, issue their appraisal summary, meet those requirements, and then just refile. So even if you're stopping them on this argument, which is fine, it's your prerogative, and we've certainly done it before, just bear in mind that that's not going to be a full stop to the project. If you want to stop the project, which is a fairly common question that we get, what I tell people is the time to stop projects is the time when they're being designed and, I guess, contemplated by the local government or the state. Meaning stopping the projects is usually a political process more than it is an argument in eminent domain. You certainly can, again, raise objections to the public use of a certain road project, or what they're taking, and you can certainly potentially prevail on that, although it's very difficult. It is possible. Just bear in mind that a lot of these objections are fact specific. So if you feel like the DOT didn't follow the law, or the project that they are ultimately building is not for a public use, then we can talk about that further. I'm happy to have that discussion. It's a very fact intensive discussion, so I'm not going to get into it too much now. So back to the process. You're at the initial hearing. You have the opportunity to challenge it. There's a decent chance that you're not going to object to that because they did follow the law, and it'll be stipulated to, and probably not even necessary to be held, that initial hearing. But in any event, you do have the opportunity. So after this initial hearing, what happens then? Well, the court will appoint 3 disinterested commissioners, and these commissioners are their duty is to come out to the property and appraise the property and come up with their own determination of just compensation. So prior to the litigation filed, the DOT came up, had their appraisal. The petition was filed. The court appoints 3 disinterested commissioners to determine their own amount of just compensation. And their goal is to determine what I'll refer to as preliminary just compensation. And their job that they will do between 45 days of getting appointed by the judge, they'll come out, they'll look at the property. You have the opportunity to present evidence to these commissioners if you'd like, but ultimately they'll come up with their own determination within 45 days of their appointment, and they'll come up with a number. So let's say that the DOT offered $20,000 for your property. The commissioners came out and they determined you're entitled to $40,000. What happens then is that once the DOT deposits that preliminary just compensation that's been determined by the commissioner with the court, so that $40,000 figure, once they deposit that, they actually take title to the land. Now, this is referred to as quick take in a lot of states, but ultimately what it means is that the DOT, the state, the county, municipality can gain title to the land for purposes of doing their project before final just compensation has been determined. So what that means, again, so they deposit that $40,000 that the commissioners felt was appropriate, and in exchange, they get title. Now, the landowner, if they choose, can file what's referred to as exceptions or objections to this commissioner's award. So let's say that you actually think you're entitled to $100,000, not $40,000. You can file an exception to the commissioner's award of $40,000 and say, we disagree with that. That's still wrong. And once you do that, and you do have to do it within 30 days, if you don't do it within 30 days, that whatever that amount becomes the final amount. If you object to that $40,000 as an example, ultimately, then you have the ability to take the case all the way to a jury trial. And the preliminary just compensation is not relevant anymore. And ultimately, the jury will determine what your final just compensation is. So if you think, again, it's entitled to 100, the commissioners say you're worth 40, you object to the 40, the case continues on, the DOT takes possession of the land, and ultimately the only issue left at litigation is the amount of money you're entitled to. The DOT will have taken the land at that point, and it'll all be about money. And that's how it works. And I want to say that this is a full process. This is from beginning to end. Not every case gets to jury trial. As a matter of fact, it's a pretty rare instance for these cases to reach jury trials. They certainly happen, but they're rare. What that means and why that case is that oftentimes cases settle. Sometimes they resolve pre-suit. Sometimes they resolve at litigation, but generally most cases that we deal with, I'd say 90% of the cases that we handle, and that's across all the states we work in, you're probably looking at about 10% of cases actually reach trial, if not less. So what is it? What are we talking about? What is just compensation? How can the DOT say one thing that can be so wrong than what you're ultimately entitled to? And what I put together here is what a complete just compensation package. So this is for your case. A complete just compensation package should include all of these aspects if relevant. If it doesn't, it's possible that you are not getting the full amount of what you're entitled to under the law. So every landowner, and this applies to any acquisition, should have a proper value for the underlying land. What's the value of the property being acquired? What's the price per acre? What's the price per square foot? A lot of times the DOT will undervalue your land. They will look at comparable sales, which determine land value. They'll look at improper comparable sales. They'll look at comparable sales very far away, or they'll look at comparable sales that are much larger, much smaller than your property, or they are not the same, not being used the same. They're not in the same location. They were sold a long time ago and therefore are not relevant. Compare just because an appraiser slaps some sales of properties into an appraisal, it doesn't mean they've ignored other sales that exist, or doesn't mean they haven't ignored other sales that exist, or not properly considering the ones they did include in the appraisal. So it's important that just because they have a land value, just because they have an appraisal, it doesn't mean that appraisal doesn't have severe errors in it. As it pertains to the underlying land value. What's important also is to consider the highest and best use of the property. The highest and best use of a property is the use of the property that brings back the most economic benefit to the owner. An example of this where the highest and best use is different than the actual use or the interim use would be a residential property that is surrounded by commercial land, and its development has enveloped it. It is the last holdout. But it's still being used as a residence. A good example of the highest and best use of that parcel might be commercial versus residential. Even though it's being used residentially, if it were to sell in the open market, it would likely sell commercially, and therefore it should be valued as commercial land. This is an example of how highest and best use can benefit a landowner's compensation. So beyond that, there's also the damage to the remainder. And this is only if it's a partial taking. A partial taking, as you might guess, is an acquisition where they only acquire a portion of the property, of your property. So if you have a 5-acre lot and they only acquire 1 acre of it, that's a partial taking. And usually for partial takings, this is the biggest disagreement between the parties. And it's ultimately, how does the acquisition of that 1 acre affect the remaining 4 acres? And acquisitions can affect, or the remnant, as it's referred to, the 4 acres that's left over, they can affect it in many different ways. If they take access, if it renders the property non-compliant with local zoning, if it makes your house closer to the road. Reduced setback is a very common source of remainder damage. That's what it's called, where you have a house that maybe prior to the project was 100 feet from the road, and now it's going to be 40 feet from the road. That reduced setback from the roadway can oftentimes impact the remainder parcel negatively. And it's important that you get paid for that impact on the remnant, just like you get paid for the 1 acre they're taking. But ultimately, partial takings can cause consequential damages in any number of ways. And that's because property, businesses, they are tailored to the lot they exist on. Everyone, when you buy a piece of lot and you start developing it with whatever you're putting on it, you're doing it with the expectation that you have all of the entirety of the lot. And when somebody comes in and takes a portion of that lot, it can throw the entire lot into haywire, and it could, your lot may have been set up for specific use, and that use is no longer possible because of this acquisition. That affects value. You are entitled to that difference in value. So, these are all, remainder damage can occur in many different ways, and we're happy to evaluate your case to look for those potential sources for remainder damage. If you are being relocated, if you have a house or a business that is going to be relocated or taken in its entirety, it's important that you get comprehensive relocation expenses. The relocation is actually a different compensation package than the just compensation. The just compensation is for your land and any impact on your land. The relocation is for the business or the house that exists on that property. And a lot of times, especially with businesses, relocating a business is not as easy as just picking up and moving and putting it down. There's a lot that goes into that. And many times the DOT does not offer proper relocation packages. So that's also something you're entitled to. And then 2 components that are unique to Missouri law are homestead value and heritage value. So in the state of Missouri, unlike all the other states that I'm licensed in, for example, if you have your house that's being taken or it's being rendered unusable because of the acquisition, you are not only entitled to the fair market value of your property and your house, you're actually entitled to 125% of fair market value. So whatever the fair market value is, let's say, you were to list your market or list your property on the market for $400,000, and your property was worth $400,000, you would actually be entitled to $600,000 under Missouri. Excuse me, that's homestead value. I was looking at heritage value. Excuse me, $400,000. It would be $500,000 if they're taking your residence or your dwelling. So that's a bonus in Missouri law. It's something to consider when you're negotiating. This is definitely a component that you're entitled to. Heritage value is the other one, and that is you actually get 150% of fair market value, but that's only for properties that have been in your family for 50 plus years. And you will have to demonstrate title and how you had consistent ownership for 50 plus years. But if you can demonstrate that, you can get a bonus, basically, payment. You get more money than you would otherwise get if you aren't able to prove it. So that's two components definitely you want to keep in mind. And I know we're at 26. I'm going to go over probably about 5 minutes or so, just as an FYI, but I want to let you guys know that. Now I want to talk about what to do when you get that good faith offer. Because really for us, that's the beginning of the eminent domain process, even though you're pre-suit. What happens with this is that right-of-way agents are hired by the DOT, they're hired by the state municipalities to come out, and their job is to negotiate with you and get your land effectively. That is their duty, and that's what their goal is. It is not to help you get just compensation. It is not to ensure your interests are protected. Right-of-way agents' duty is to get your land for as cheap as possible. So I say that to keep it in mind when you're talking with these people, if you choose to talk to them. But this is how to deal with right-of-way agents. This is how to ensure that you don't make any mistakes in the pre-suit negotiation phase of the process. So when you get that good faith offer, what I tell people is always communicate with right-of-way agents via email. They're going to send the offer probably, again, via certified or registered mail. I'd also ask that they send it via email. So if you're a landowner, say, we got it, but we'd like an e-copy, please send, or you can just scan it yourself. But in any event, once you receive it, if they communicate with you, if they want to talk and have a discussion, I tell people, hold off on that discussion. You communicate with email, inform them that you receive the appraisal, and then you'll get back to them in a week. Nobody's going to do anything in the interim week that you've given yourself to review this offer and this appraisal. So I think this is an easy way to handle right-of-way agents. It gets them out of your hair at least for a week, and in that week you can then figure out what you want to do and how you want to handle the case, and if you're going to hire counsel. So once the offer is received, and if they start a dialogue with you, I respond back again via email or text. I would keep everything on the record, so to speak, everything written. I'd avoid in-person discussions, verbal discussions, because verbal promises by right-of-way agents mean nothing. So ultimately, there's no point for you to have these discussions in person verbally, where it's effectively their word against yours on what happened. I would definitely err on the side of having written communications with right-of-way agents. But in any event, I would, once you get the offer, inform them you got it and that you're going to get back to them in a week. And then if you'd like, you can contact me. I can look at the offer for free and give you my thoughts, and then you can decide what you'd like to do. Again, I would avoid in-person discussions and negotiations. I definitely seek out some assistance as soon as you get that offer. So that's what you should do when you get an offer. Contact an attorney, get a review, and decide your approach. What not to do. So these are some pitfalls we've seen from landowners in the past. They get their offer and they do what they feel compelled to do, which is usually start negotiating. And what we tell folks is do not engage in these negotiations or discuss the value or discuss the property before contacting an attorney. It might seem, again, second nature if they come to you and they make an offer for you to counter, but the reality is that you might not know what the counter should be. And if they come in and offer $20,000 and you come back and say, well, gosh, I'll double it to 40, and they agree to that, but the reality is that maybe you were entitled to 100 or 150 or 200, but you didn't know that at the time. And so what I tell people is that doubling or even tripling a terrible offer doesn't necessarily make it a good offer. It might just make it a less bad offer, but still not appropriate. And so, doubling these offers, just as an example, people maybe sometimes feel like they're getting a good deal, and it turns out they left thousands of dollars on the table. So I would not discuss value before talking with somebody that knows what they're talking about too, not just anybody. I would talk to an eminent domain attorney who has experience in this to get a case review and then go from there. Don't enlist an appraiser. You certainly can if you'd like, but I would not, generally, because they get an appraisal, landowners generally think, well, I got to get an appraisal. And it is possible that you will need an appraisal eventually. I'm not saying that is the case, but what I tell people is that it might not be necessary. Sometimes our firm is able to negotiate deals, as an example, without getting appraisals. And eminent domain appraisals are not cheap. They are pretty expensive. And so if you are spending that money on something, it's imperative that you're getting your money's worth and that you're going to the right people, and that it's necessary. Again, it isn't always necessary. We've negotiated quite a few cases pre-suit without getting appraisals. It's my view that appraisals are not necessary unless you're in litigation. Once you're in litigation, you have to prove up your value, and it usually requires an appraisal. But until that point, it might not be necessary. And if it might not be necessary, it's better to hold on to that money that you would otherwise spend on that appraisal if you don't need to spend it. Again, don't meet in person with right-of-way agents. Don't take promises at face value. Everything in writing. I've heard all sorts of promises issued by right-of-way agents that don't come to fruition. Again, their verbal promises are not worth paper they're written on. Do not assume the DOT has your interests at heart, because often they don't. Just bear that in mind when you're talking with these people. And then finally, don't make a rush decision, but also don't ignore it altogether, because we do have time deadlines. And if you get an offer and you don't do anything with it, for 30 days, you might end up in litigation. You might end up in eminent domain. And, a lot of people are scared of eminent domain. And what I tell people is that if your case is at eminent domain, is in litigation, it should be because you want the case to be in litigation. It shouldn't be because you didn't do anything and then they just filed suit and there you are. Because sometimes eminent domain is not the venue where you should be resolving the case. Some cases require it, some cases don't. And we evaluate and we can inform you what we think when it should resolve. But just keep in mind that not every case should go to litigation. And so that's why you should make sure that, you don't ignore the case altogether, let the 30 days lapse, and then you're in court, you don't want to be. But at the same time, don't make a rush decision. I think if you follow my advice and just wait a week, you won't be making a rush decision. Okay, and we're almost to the end, folks. We're going to talk about my fees, our experience, and then we'll take questions. So just an FYI, how our firm operates. For a big question I get, how do we get paid? If you're interested in working with us, we operate on a contingency fee basis, and our fee is contingent on how much more money we get for you than what is offered by the DOT. So, as an example, if you're offered $10,000. We get you $50,000. If you hire our firm, we get you $50,000. And sorry, this is the wrong. There we go. We get you $50,000, and in that case, we added $40,000 to the case. Our firm gets a third of the $40,000 that we added to the case. You get the remnant. Our fee comes out at the end. In this scenario, you would get more than 3 times the initial offer, almost 4 times the initial offer. We do this several ways. One, because we understand people don't want to pay for attorneys. They don't want to come out of pocket to pay for attorneys. So this allows landowners to hire our firm without sending me money or sending us money to reserve our services. Our firm gets paid on how well we do for you and how much more we get than what is offered. This effectively puts us as partners in the lawsuit, in the litigation, in the acquisition. So we both have the same goals, we both have the same interest, and that's getting as much money as possible. And it's been pretty effective thus far. And this is my second to last slide. I will, just touch on this real quick. We are a results-based law firm. We obviously we pride ourselves in our experience and our knowledge, but we pride ourselves, I think, more on what kind of outcomes we can get for landowners. There's one thing to know the law, there's one thing to practice it. And these are just some examples of really where it can start and where it can end. This is exemplary of how bad DOT offers can be, and how just because they have an appraisal behind it, and that appraisal says $15,000, for example, that it couldn't also be true that another appraiser says you're entitled to $3 million. Now, I'm not saying that's your case. I'm not saying that these are where you should expect your case to end up, but these are real results. These are real examples of how bad, how low offers can be, and how wrong they can be when they come through and make these offers, and how on the other end, how right you can be. So these are just some examples of many. Again, these are not guarantees of success, but in all of these cases, we were able to substantially increase their offer. So next steps, and this is my last slide, and we will open up for questions. What I tell people, as soon as you get the pre-filing notice, that first piece of first letter from the DOT, from the condemner, that's when you should begin contacting vetting attorneys. Once you receive that offer, that's when you should be hiring an attorney. The time, there isn't a lot of time between that offer and the litigation potentially. So that you should be hiring an attorney as soon as you get that good faith offer. Until that point, until you get that, the more you learn about the project, the better. You're attending this webinar, so you're definitely ahead of the curve. Identify your priorities and goals, what you want to get out of this litigation, what you want to happen. If you have a group of landowners, this is just something we throw out. Most folks don't, but if you and your neighbors are all in this together and they want to go under the same representation, let me know. That can allow me to reduce my fees. If you have a group of landowners, you can come that are all represented by me. And then with that, I will take questions. Further, I want to make note before I get into that. If you have an offer, or when you get an offer, please do not hesitate to send it to me for a free review. I will review it 100% fee. We do not bill. We do not charge for these case reviews. All you need to do is send it to me at my email address, jordan@landownerattorneys.com. You can text it to my cell. You can fax it to our fax machine. You can call our office and let me know you have it. You can mail it if you'd like. Our address is on our website. But please don't hesitate to take advantage of that. Again, completely free. We do not charge for that type of review, and we are happy to provide it to anyone who has an offer. So with that being said, I am going to come back here and see if there are any questions. Okay, I am not seeing any questions. Oh, there's a raised hand. We're actually going to do just writing questions. So if you have a question, just, I guess, use the chat button, or the chat app here on the right, or the Q&A here at the bottom of your screen. So yeah, if you can use those functions, I can answer the questions that you have. Okay. Not seeing any questions, which is fine, not a problem. If you think of something later that we didn't touch on or you didn't think of at the time, just shoot. Oh, again, we got hands raised. Okay, so we're not going to do. All of our questions are going to be in writing. We're not going to do the verbal thing. So if you have questions, again, use the chat or the Q&A function at the bottom of your screen. So it sounds like people have questions, but I want to make sure you get an opportunity to ask it. So Again, use the chat. Okay, I think there we go. We got it. Okay, question. The first question I got, do you know how long it takes to get an offer, and do you know how close to your house they're going to go? So the question is when you get your offer, and ultimately who determines when you get your offer is the DOT. They go at their own schedule. They operate on their own schedule, and they will come to you when they want your land. Eminent domain is a responsive area of law where you don't initiate the litigation, you respond to it. So you respond to the offer, you respond in turn, and it's not something that you can force. The issue is not forced by the landowner. So, when you get the offer, it really just depends on when their process and their schedule. And so they are how close to your house they're allowed to go is another great question, and that is the setback discussion we had previously. Theoretically, they can put the road as close to your home as they'd like. Now, if they put it within 5 feet, for example, or 10 feet, then your argument is that yes, you haven't technically taken my home, but you effectively have taken my home, and therefore you will take my home, or pay as if they took the home. So they're not under any sort of requirements that they do have their internal processes and how close they'd like the road to be, but ultimately they'll put it as close as they'd like to. The question ultimately for them is whether or not they go ahead and take the home, or they make you argue as if they took the home. So they can come as close as they'd like. The question is whether or not they give you an offer for the damage they're doing to the home by putting it so close, or whether you're going to have to fight for that yourself. So they can come as close as they'd like, but you're probably going to have to make them pay for it. Or alternatively, sometimes if they're coming so close and you're concerned that no compensation will do it, you might have to negotiate a change in the path of the road to make it further away from your house, which is something that sometimes can be done, something we've done in the past. So, second question, what if the 30 days has passed? Can you still help? I presume that's the 30 days after the pre-filing offer. Absolutely. If you have an offer in hand, we're happy to look at it, whether the 30 days has passed or not, because again, it's at least 30 days. Just because the 30 days passed doesn't mean they're going to file suit the next day. If they did, you would receive service of that lawsuit. So we are more than happy to help folks at any time in the process. I can't guarantee representation, of course, but I will review your offer pre-suit, at suit, at litigation, et cetera. It's not a problem. We help people from beginning to end. So yeah, we can definitely help after 30 days have passed if that's the case. And then I think a follow-up on the first question about the setback issue is an example of the dangers of being close to roadways, and that is a history of a semi in this example coming into your front yard, a motorcycle accident, a fatality, all of these things. What you're describing is the reason why people don't want to be close to roads. And that falls underneath the the umbrella concept of setback reduction. So again, homes generally, when people buy homes, they want to be far away from roads. And if you put that, why do they want to be far away from roads? Because of what you or the examples you presented, a semi, there's the noise, pollution, the danger associated with cars coming in the front yards, accidents, all of the things that are associated with roads, and the reason why people don't want to be near them, all of those potential outcomes, they fall underneath that umbrella concept known as setback reduction and remainder damage. So you're absolutely right. People don't want to be near roads because of these accidents. And as a consequence, if they have to buy a home that's close to a road, they're probably going to pay a lot less. And that means that your home, if it's put significantly closer to the road and the accidents and the noise and pollution, that your home will also suffer some sort of compensable damage due to this lessened setback. So you're absolutely right that I should say that these types of damages exist. These are real effects that are realized. So it's important that that if they come particularly close to your home, you get paid for it, or you negotiate it away from your home potentially not quite as close. Okay. Other questions? Okay. I do not. Oh, another question. Yeah, it's more of a comment about the discussion with the DOT, thinking the 30 days didn't matter. I want to again emphasize that these days are minimums. In that the 60-day offer is a 60-day minimum, or a 60-day notice is a 60-day minimum, and the 30-day offer is a 30-day minimum. It is not uncommon for DOTs to for that time frame to extend significantly. The same concept exists in Illinois. I've had folks with these 60-day notices that are a year old. Now, all that means, again, it's a purpose, but sometimes they can't file, and sometimes they will if it's an expedited project. So, it might not matter in the grand scheme of things, the time period, but it's also something that you can't rely on, because if they can file the next day, then you have to be prepared as if they will. But again, just because they notify you doesn't mean they're going to file it on that 31st day. So it's possible that in your situation, the time frame doesn't matter, but ultimately the issues are the same. How is it going to affect your property? It's going to affect your property this way now, just like it's going to affect it 30 days from now the same way. So, ultimately the issues stay the same, but the time frame might change. I just provide statutory minimums. Okay. Any other questions? Okay. I am not seeing any other questions, so I'm going to go ahead and wrap this up. Folks, thank you so much for stopping by. I appreciate it. You have my contact information. Please don't hesitate to shoot me an email, shoot me a text, shoot me a call if you have questions or anything like that. Otherwise, thank you for attending, and good luck.